respected Sri Narayan Swami, Mr. Ravi, and very, very distinguished members of the audience. As I am late, I will not take names, but there are so many illustrious people here. I am very humbled that all of you are present. I must just make a small correction. This is my second speech at the Triplicane Cultural Academy. I spoke once with Justice Sri Krishna, and of course the long list of people are so eminent that it is really a privilege to be speaking here. Before I start, I must sincerely apologize for the delay. The fault is entirely mine. I noted the time in my diary as 6:30 and did not know.
We had passed it over. We had passed it over.
Passed it over. How much? Thank God we didn't adjourn it. So I did not know the change in time. It's my fault, Mr. Pasad. He called my office. My apologies. I think the worst thing that a speaker can do is to keep the audience waiting. Now, why did I choose this topic, the right to privacy? Actually, I expected that by the time 19th August came, the Supreme Court would have delivered the judgment on the right to privacy. And I chose this topic because I had occasion to appear. Actually, how did this entire problem come about? For nearly 40 years, nobody disputed that India had a right to privacy. Nobody. But on the 11th of August 2015, when the Aadhaar case was just about to start, the Attorney General, the then Attorney General, made a statement that invasion of privacy is of no consequence because our constitution does not recognize a right to privacy at all. Indian citizens have no right to privacy. And that was an astonishing and startling statement. But why did he make it? This statement was made because of two observations in two judgments in 1954 and 1962. I believe maybe this was a device to say that it should be shifted to a larger bench, the matter gets deferred. But right at the end, beginning when the Aadhaar was starting, the Attorney General said we have no right to privacy. In 1954, the Dalmia group of companies were raided. Their premises were searched, documents were seized. The Dalmia company argued that this is violation of my right to privacy. My documents are my own property. Nobody has a right to see them. It will amount to incriminating myself and therefore it is invalid. And the Supreme Court, now this was a simple case of search by a company, by the Department of Company Affairs, nothing to do with privacy. But the Supreme Court, Justice Das, in passing he mentioned that India does not have a right to privacy like the 4th Amendment to the US Constitution. That's just one line there, nothing. It was the end of it. And they of course said that there is nothing wrong in this search and that matter. A more serious case came in 1962, which is the historic Khadak Singh case, as any person knows. Now, Uttar Pradesh had certain rules whereby the police could follow your movements, number one. They could picket your residence, number two. They could maintain records and data of history sheeters, that is people with criminal records. The fourth is very significant. The police were entitled to make domiciliary visits at night. In other words, they could knock your door and enter your house at night and search. Now, Khadak Singh was one of the accused persons. He had a bad record. He had a criminal record. And he complained that the Daroga or the police would come knock at his door at odd hours in the night, ask him where he is going, whom is he meeting, who is coming to see him, and so on and so forth. Now, this was challenged before the Supreme Court. Now, before I continue, you should remember that the first judgment I mentioned, that Dalmia case, was by 8 judges. Khadak Singh was by 6 judges. Now, in the Supreme Court, again it was argued that this violates the right to privacy. It is violative of Article 21, right to life and liberty. Supreme Court said nothing wrong in picketing. Nothing wrong in following you where you are going. That is shadowing, surveillance, nothing wrong. Nothing wrong in maintaining your history records, the records of the history sheeters. But they struck down the provision regarding domiciliary visits. They said, no, this can't be done. In that again there is one sentence. There is no right to privacy in India like the 4th Amendment. So basically this no right to privacy was in two sentences in the Supreme Court in 1954 and 62, that was all. That was picked up by the Attorney General and said, look, 8 judges have said so. If you want to say right to privacy, constitute a 9-judge bench. And that's how the case went to the 9 judges. There's no need at all, but that's how it went. But in a sense, it's a good opportunity because the Supreme Court will now lay down whether there is a right to privacy. Now, there were 4 of us who argued the case before the 9 judges. And because of the rationing of time, I was allotted the task of expounding the law, US law on the right to privacy. That was my role. But I sat through the argument, so I know exactly what happened. The Union of India argued, you have only a common law right of privacy, you don't have a fundamental right to privacy. Now a layman will ask, what is this distinction all about? What is this great difficulty between a common law right and a fundamental right? The distinction is very critical because if it's a fundamental right, you can straight away challenge, file a writ petition and get that thing quashed. Narco-analysis, putting truth serum into a body. If you did not have a fundamental right, it could not be challenged. You have to file a suit in the city civil court or the high court. In many states, the high court don't have original jurisdiction. You have to go to the local district court, the city civil court. You file a suit and you battle it out. You don't have Article 226 or Article 32. You can't approach the Supreme Court or the High Court. So this was the background as far as the right is concerned. We argued the case, the reserving judgment. So within the next 5 days, all of us will get a 9-judge bench which will decide what is the law of privacy. Is it a fundamental right? Or is it a common law right? Is the right to privacy applicable to private parties also? So what the 9 judges hold, because it's very difficult to get 11 judge bench, so what they now hold will govern the law of India for the next 50, 60 years. That will be the law. Now, the Supreme Court incidentally will deliver 2 important judgments this week. One is on this privacy and the other is on triple talaq. The 2 important judgments have to come by the 25th of August because Justice Kher is retiring at that time. Now let me come back to the subject. What is this right to privacy? Now, privacy as a word is incapable of definition. In fact, a peculiarity of the English language or perhaps any languages, the more common the word, the more difficult it is to define. How do you define beauty? How do you define religion? How do you define peace? Can't define it. Can't define privacy. In fact, all jurists, because we did a lot of research in the 9th judgment, we went through many articles and so on and so forth. Nobody is able to define what is privacy completely, but perhaps the best definition is by what Mr. Ravi quoted, Justice Brandeis, the right to be left alone. The right to be protected from unwarranted state intrusion into your space. Now before I go further, to save time, I'll just tell you that privacy can be divided on the basis of the research we did into 3 components. One is physical privacy, that is privacy of your home, privacy of your body. Second privacy is called informational privacy. Privacy about information, about your own information, your personal information, data, etc. And the third is called decisional privacy or decisional autonomy. The right to take decisions of your own, the person whom you will marry, whether you have children or not, all these are decisional autonomy issues. So broadly we talk of physical privacy, informational privacy and decisional autonomy. If you keep this thing in background, then it will be easy for you to follow. Now, I decided to divide my talk into 3 parts. Basically, what is the US law on the subject, how it developed. Secondly, what is the Indian law on the subject. And thirdly, what is the future in the context of Aadhaar. And I may tell you, on 6th September, we are having a very important case of WhatsApp and Facebook. That's a privacy issue of private players. Can you have consensual, voluntarily giving up data? Can you waive your fundamental right? These are the issues coming up there. And incidentally, I am involved in that case also. I appear for Facebook. So that will be a case of privacy with private parties. Aadhaar is between government and the citizen. Facebook, WhatsApp are between 2 private parties. Now coming to the US law. You see, the American Constitution, in 1776 you had the Constitution. In 1789 you had a number of amendments. And the 4th Amendment to the US Constitution basically says that no person's home can be searched without a proper warrant. That's the long and short of the Fourth Amendment. In other words, as the US Constitution puts it, your home is completely safe. In 1572, Lord Hope said, every man's home is his castle. It's a Hope expression. All of you have heard, my home is my castle, and I'm entitled to do what I like within that place. So, in 1789, the US Supreme Court said that nobody can be searched or his house can be entered without a proper warrant. In other words, it was a privacy regarding your physical spaces. Now, fast forward to 1926. That was the days of extensive prohibition. All of us know that prohibition was a huge issue in America in those days. And there were some bootleggers whose phones were tapped, wiretapping, by the FBI. This was challenged in the US Supreme Court, saying that it's a violation of our right to privacy. The Supreme Court said nobody's come to your house. Your privacy is only your home. If I tap your phone call, I am not violating your physical space, therefore there is no violation of a right to privacy, and it's Homestead versus the state. But in that case, Justice Brandeis, who first wrote an article in 1890, he became a Supreme Court judge by 1926. He dissented and he gave the historic statement, the right to privacy is the right to be let alone. That was the statement he made. So in 1926 they said wiretapping doesn't matter, as long as they don't enter your house, I have not violated your privacy. 20 years later, another case came, Katz versus US. This was a time where there were other illegal activities going on, I think regarding gambling. Bookmakers and gambling, there was a activity. And a person would make a phone call and pass on information. Again, the FBI was investigating. So what they did was, you must have all seen the old phone booths. I don't know, the younger generation may not see the old phone booth. You have you open the glass door and go and make a call and so on. So what the FBI did was, they put a small bug, a wiretapping device in the booth. And they could record his conversation. This was challenged. And they said, nobody's entered your house. We did not go into the phone booth when he was speaking. He spoke, we recorded, that's all. But this time the US Supreme Court said, the right to privacy is not just entering your home, even your personal spaces are private. What you speak to, whom you speak to, what you speak to are all private. They cannot be interfered with except on the basis of a warrant issued by a concrete court. So look at the great shift from physical spaces it went to personal spaces. Now go fast forward to two more cases in the US. You'll be astonished that as late as 1965, it was an offense to sell contraceptives to couples because birth control was not permitted. So in Griswold versus Connecticut, the US Supreme Court struck down a law which said that you can't sell contraceptives to married couples. They said that's a matter of decisional autonomy. It is my choice whether to have a baby or not. In what manner I conduct my private life is my entire thing. It's a masterly judgment, Griswold versus Connecticut. And it will be equally surprising to note that till 1972, you could not sell contraceptives to unmarried couples. So they said you can sell to married couples, but if you sell to an unmarried couple, it's an offense. Again, the matter went to the Supreme Court, and they finally said no, even an unmarried couple, it's entirely your choice what you do in the privacy of your home. That is in 72, Eisenstadt versus US. And finally, I'll not go too much into US law. Finally, the famous case of Roe versus Wade, the abortion case. Many states had anti-abortion laws. They say to abort a child is to take life, is to kill life. The people who wanted abortion, they said it's my right. Suppose it's an unwanted pregnancy. It's my choice whether I should have my baby or I should not have the baby. So finally the Supreme Court made a via media. They divided pregnancy into 3 trimesters. In the first trimester, it is entirely the woman's choice. She can decide to terminate the pregnancy or go ahead. It's her choice. The state cannot interfere at all. Total decisional autonomy to the woman in the first trimester. In the second trimester, the Supreme Court said that yes, she can do it, but under state supervision on the basis in the hospital with the presence of a doctor and so on. But in the third trimester, the argument, it's a very beautiful judgment worth reading. In the third trimester, they said the fetus can live outside the womb. The baby after, I think the third trimester starts after 7 months, or after 28 weeks. So the baby can live on its own. And there they said the state has the right to prevent abortion. They can say no abortion in the third trimester unless it is dangerous to the mother's life itself. So you have to balance the act between, if there is no danger to the mother's life, in the third trimester, a state can prohibit abortion. Of course, there are many, many more cases. There was a law in the US that if a person is a habitual criminal, he could be compulsorily sterilized. Supreme Court struck it down. They said no. Another case, they said, if you read pornographic literature, it's an offense. Even in your house, Supreme Court said no, what you do inside your home is entirely your business. And of course that has now gone to same-sex marriage and so on and so forth. This is the US law of privacy. Now in India, how is it developed? Just some examples and I'll move on. I mentioned these two cases where there was a right to privacy in passing. But after Maneka Gandhi, people said that look, you have the right, your basic rights are there, you can't take away your right to make decisions on your own. And how has privacy been taken up in India? I'll just give two examples to show. All will fit into these categories: physical privacy, informational privacy, and decisional autonomy. Take the case of X versus Hospital Z from Madras. There was a doctor from Nagaland. He was an ND, postgraduate. He came to Chennai with another person. The other person was ill. So he came with his relative to Chennai for treatment of that person. Now that person required blood. So this MD doctor and his driver who had come down gave blood. And then they found that this MD doctor was HIV positive. He was engaged. The doctor intimated to his wife that he was HIV positive. He said, you have no business to tell that my HIV status is my privacy, it's part of my bodily information. It can't be parted to anybody else. But the Supreme Court said no. They said, just as your information is important, the life of your future wife is equally important. And they relied on two sections of the IPC which said, if I am capable of doing something which will make another person sick, it's an offense punishable with 2 years. If I can cause malignancy in some other person, it's an offense punishable. They said nothing wrong in the hospital giving records, but they said they've given certain guidelines. That was one case of, it's called X versus Hospital Z. It's a case of Madras. Other case, Auto Shankar's case. As all of you know, Nakiran is a magazine, and it had decided to serialize. Auto Shankar wanted to write his autobiography. And the police kept on putting pressure on Rajgopal, who was the publisher, saying that you can't publish this. He went to the Supreme Court, an elaborate discussion of right to privacy. They said he said that if you publish this book, many IAS and IPS officers will be in danger. Their lives will be troubled. Supreme Court said nothing wrong. He has got the right to publish it. If there is the defamation laws will take care of it. You can't stop this. And they allowed the publication as far as Nakiran is concerned. I'll give a third case and I'll go on to, and I'll just mention the Aadhaar issue. Third interesting case is Selvi versus Karnataka. All of you know that all investigation wants to get at the truth. Did Mr. X or Y commit the offense or not? So you have heard of third degree methods. Police torture is there, they extract confessions. This was what is called narco analysis. And if you see the judgment, they give you a particular chemical, I think it's sodium pentothal, which is basically given for general anesthesia. Now, for a human being, there are basically 4 states. Your awake state, the hypnotic stage, the second stage, the third stage is sedative stage, and the fourth stage is the anesthetic stage. Now, if you administer this particular chemical, which is colloquially called truth serum, into the body, a person gets into a hypnotic trance. His inhibitions drop. There is evidence for and against that at that point of time a person starts speaking the truth. The matter went to the Supreme Court, very, very elaborate judgment. on narco analysis, on compulsively taking evidence, and finally the Supreme Court said you cannot compulsorily inject chemical into a person's body without his consent. It's a violation of his physical privacy, it's a violation of his bodily integrity, violation of his bodily privacy. Criminal law is important, but a person's individual rights are equally important. So these are the three cases I've given as far as they're concerned. And recently a very important judgment came from the Supreme Court. There was an unwed mother. She applied for her child's birth certificate. They said, I will not give it unless you disclose the father's name. Then she went to court, said, I want the birth certificate and I want the guardianship certificate. I want to be the guardian of my child. The trial court said, no, unless you disclose, because the form says you must disclose your father's name. She said, I don't want to disclose the father's name because the father was married and she said, if I disclose his name, it will ruin his life. What happened? I want to raise the child, I don't want to disclose who the father is. Delhi High Court dismissed it saying, this is the law. If you want a certificate, disclose the father's name. The matter went to the Supreme Court, and in a very nice judgment, Supreme Court said, no. Who her father is a matter of her personal information. If she doesn't want to disclose the father's name, you can't compel it. And they have issued directions all across the country that nobody can be denied a birth certificate or a guardianship certificate to an unwed mother because she does not want to disclose her father, the putative father's name. So, ladies and gentlemen, these are the important laws where the US law has progressed, Indian law has progressed, and slowly and surely the right to privacy has developed. That is why in this atmosphere, with this background, there are 64 cases of the Supreme Court where the right to privacy is recognized in one way or the other. We tabulated them and gave it to the court. With all this background, Attorney General says there is no right to privacy. And then that went from 5 to 9 judges, and let's see what happens in the next 96 hours. We'll know the outcome of whether we have a fundamental right or not. To me, it will be shockingly anachronistic that in an Indian democracy where there is rule of law, you can come and say that there is no right to privacy at all. Now finally we'll come to Aadhaar, and then I'll somebody wants a question answer there, I can answer it, but I'll just conclude my talk with Aadhaar. I did the Aadhaar matter on the income tax issue. In this year's budget, there was a provision that unless you disclose your PAN card number, your Aadhaar card number, your PAN card becomes invalid. Which to my mind, to my limited intelligence, I can understand the logic. I'm an income tax assessee for 10 years, 20 years, 30 years, some of you are assessees for 40 years. We've got PAN card definitely for the last 20 years or more. Now, how does giving my Aadhaar card or not decide whether Arvind Datar is Arvind Datar? I don't understand. And secondly, when you apply for a PAN card, you have to show your passport, you have to show your voter's ID, you have to show information, and you get your PAN card. But the standard plea of the government is there is terrorism, Jammu and Kashmir. We don't know which people are coming in. There are fake PAN cards. We showed a parliamentary statement that only 0.4% PAN cards are fake. I said, why are you torturing 99% people who give their Aadhaar card and link with PAN card? But nevertheless, we lost the case. The Supreme Court said, no, there's nothing wrong. Because our argument was this, and I'll come to the Aadhaar controversy now. What is Aadhaar? If you take the Aadhaar, first was an executive order. Somebody said, or some bodies, association said, we are giving subsidies, gas connections, or what is called entitlements and subsidies. How do I know that it is going to the right person? How do I know that this is not Arvind Datar, it's somebody else? And very often in the rural area, the person may not have a birth certificate, he may not have any identification, he may not know when he was born. So many, because in 125 crore people, these information, these data are not available. So the finest thing is your iris and your fingerprint. So they said, let's have Aadhaar. The point is, by giving the thumb impression, your photo pops up on the screen and they say, yes, you are the right person, you can take the gas. Under Section 3 of the Aadhaar Act, you may apply for an Aadhaar. Now, if some of us who are fortunate to be affluent, we are not going to take a gas subsidy, we are not going to take ration, we are not going to take any government entitlement, we are not going to go to Manrega scheme. We don't require any government benefit. Why should we be asked to take Aadhaar? So our argument was, if Aadhaar is voluntary under the Aadhaar Act, don't make it compulsory under other laws. And in fact, the Supreme Court has said, except for 6 cases, you can't make Aadhaar compulsory at all. Only for 6, for all the 4 government subsidies, plus a telephone connection, and one more item, you can't make Aadhaar compulsory. Now, what is the danger of Aadhaar? In fact, in the judgment which we lost, the Supreme Court elaborately discusses how the data is completely, there is no adequate data protection at all. And that's why you must have read that Justice Sri Krishna committee has been appointed to formulate data protection laws. Now, the dangerous part of Aadhaar is this. You are linking Aadhaar with multiple things. Last Saturday, I was asked that if I don't give my Aadhaar card, my Airtel phone connection will be disconnected. Now, I had a choice of filing contempt, but then, like everybody else, you want to go on in life. There are about 20 other important things to do. It's easier to go to the Airtel counter, spend 10 minutes, give a fingerprint and come away. But it is illegal. What is the relevance of my thumb impression with my telephone? Huge lines there. Half a dozen people's thumb was not matching. And the person says your thumb is not matching to a different phone. In fact, you should think about identity of the man or the identity of his phone. But this is a comedy. So anyway, we finished. So our basic plea in Aadhaar is, there is no protection. And yet, you're going to have crores and crores of data which will be floating around and any person can have access to it. There is virtually no data protection. And the dangerous provision is section 48 of the Aadhaar Act, which says all the data is with UIDAI, the Aadhaar Identification Authority. But under section 48, the government can summon the data in public interest to do what it likes. So I do not know what is going to happen in future. I hope that there is some element of data protection. Then come to Facebook and WhatsApp or any private players. Now in the electronic age, the electronic surveillance can become all pervasive. I remember a few days ago, my family and I had gone to a small hotel in Annagar, Murugan Idli Center. Went in the morning, my wife, myself, my son, went in the morning. The moment we walked in, my son gets a message on his cell phone. Good morning, please rate Murugan Idli Center. Why? Because he's on Uber. So his phone is being tracked by satellite. So the moment we entered Murugan, he gets a ping and we see the phone. How do you rate Murugan Center? 5. 5 star, 1 star, 2 star, 3 star. Very good, good, bad. Now, we had experience. Suppose you plan to go to Sri Lanka. Try it today. Just put flights to Sri Lanka. Tomorrow when you open Google, you will get different airline offers, hotel offers, everything. So all that information is being tracked, collated and so on. Now, to what extent can it be protected? To what extent? In Facebook, WhatsApp and other private things, we say, see, because all these services are free, who pays for the entire data being stored and given and so on and so forth? So the argument of these operators is, you have parted with your data on a consensual basis. The moment you go, they will ask you a question. I agree, yes or no. Unless you think, you can't proceed. Now, Lord Denning said there is no point having a 100-page contract nobody reads. So now the law is, they highlight you the important clauses of privacy policy on the phone. And then you say, do I agree, do I not agree? So the argument of the private player is, this is not Aadhaar. Nobody is forcing you to give your thumb impression. They are not saying if you don't give thumb impression, I'll disconnect your phone, I'll disconnect your bank account, I'll disconnect your PAN card. No. You want to join WhatsApp, you join. You don't want to join, don't join. There are 8 or 9 messaging sites. There is Facebook, there is LinkedIn, there is this, that and the other. So everything is consensual. And the only way they can make money, ultimately it is used for targeting and marketing audiences. If they find in your Facebook that you have accessed 3 or 4 times some baby products, they sense that, okay, this must be a lady who's having a small child, and they start targeting you with or advertisements relevant to baby products. Now the main issue is, in a private contract, me and Facebook, me and Uber, me and Ola, when I'm part of my information, is it open to Uber to share it? Is it open to Ola to share it? Suppose they say that your information will be used for other purposes. And what is the information they give? They don't give your personal information. You see, the argument which the private players are making is this. Now, my personal information is entirely my data. Whether I fell ill, whether I had a surgery, what is my blood pressure, what is my illness, everything is my data. But if I want an insurance policy, I have to undergo a complete medical examination, disclose everything. Because if I want the benefit of an insurance policy, I must part with data to get that benefit. So the argument is, if I want to get the benefit of WhatsApp, I want to get the benefit of Facebook or LinkedIn, I must part with data. I have done it on a conceptual basis, and this is being defended on the ground of decisional autonomy. It is my discretion to part with my data. Somebody writes an autobiography. It's up to him to disclose to what extent he wants his private life exposed to the public. But tomorrow I can't know about your data and publish it without your consent. Your privacy is protected. The famous case of Michael Douglas and Catherine Zeta-Jones. They agreed for the wedding pictures to be put in Hello magazine for a huge sum. Another magazine published it. Sorry, it was put to X magazine, Hello magazine published it. He applied for injunction saying right to privacy. Then the trial court held in his favor, the High Court. In Court of Appeal, they said, no, what privacy? You have agreed to give it to somebody else. You agreed to part with your information. If somebody else has broken that thing, you can only sue damages. You can't stop that person from publishing the photograph. They have managed to get it, you sue them for damages but no injunction, because you have voluntarily agreed to part with that information. So now the debate is going to be that the difference between compelled taking of information and voluntary parting with information. What shape the law will take, we have to wait for 5 days. And after Facebook judgment, we'll have to wait to what extent the courts and the state can regulate contracts part of it. Our argument is that, suppose it's Flipkart. Can tomorrow court say, no, these terms of contracts are not proper? It's a matter of private contract. You want to buy Flipkart, go to Amazon, go to somebody else. So this is a completely protected area, and this must be part of our right to carry on business of freedom of contract. What way the law will take will be an interesting future. And finally, I'll conclude by saying, see, we don't know where technology will lead us. I think Mr. Narayan Swamy would never imagine there will be something called internet and something called Facebook, and you could get a taxi by just on the button. I mean, even as a junior, when I was a raw junior, I used to look up them in the income tax tribunal, and there was not enough. I remember standing outside to make an STD call, and then you make a lightning call. All those days are gone. So we do not know what technology holds for us in the future, which way we will go. But only my hope is, Lord Coke recognized the right in 1572. My home is my castle. I only hope that wherever technology takes us, our fundamental right to be left alone will not be disturbed. And what Brandy is called, that over all civilizations, the most important right is the protection of that private space where the man can be and become himself. Thank you.